too happy to cross-examine him because he is not letting cross-examination go on. This is not a lay witness. This is a lawyer, a well-trained lawyer. There is absolutely no reason why Birivumbuka keeps on cutting Counsel Lukwago. I particularly would be happy to cross-examine Mr. Birivumbuka.
Yeah, but the question is, you see, we are saying this is a type of error.
We have two names here. My lord, the question relates to the actual name. He's talking about Chihere, and Chihere in two different affidavits. So which one is correct? And if we insist that
my lord died. Actually, Chihere Frank.
And I am asking the question, how sure are you that it's Chihere and not Chihere? How sure are you?
But I've clarified for you, Mr. Lukwago.
How sure are you that it's called Chihere, not Chihere?
He's called Chihere.
How sure are you?
According to the report.
Exactly. Report by who?
The forensic expert.
The forensic expert?
Yes.
Who is that, a forensic expert?
This question has been already put to this witness and he has answered it. He said he is not at liberty to reveal. What are we going in, sir?
My lord, there is a reason and the council knows. The council knows. My lord, they want to take me back to the issue I raised earlier. You came here to testify as an expert, a legal expert. And you know it's mandatory in an affidavit to disclose the source of information. Is it correct? Is it the position of the law that it's mandatory for you to disclose the source of information?
But I have disclosed it.
You know or not?
I know.
It's mandatory.
Yes.
And you still insist you are going to defy a command of the law that you should disclose the source of information.
My lord, those are legal issues that we should be sorting in submissions.
You see, you are an expert.
Did I tell you so?
Oh, you are not.
An expert of what?
Of law.
Which law?
Have the accused persons raised any threat to your witnesses?
Through Chihere.
Directly.
Through Chihere.
When was that?
I don't have the report with me.
When did you come to know of those threats yourself?
When the report was availed.
When was that? When did you get the report?
I'm not the one who received the report.
You get
when I perused the file.
When?
This year.
When?
My lord, I can't remember exactly when I perused it, but it is this year.
Which month?
I can't recall.
Who gave it to you?
Mr. Lukwago, I'm a prosecutor.
Who gave you the file?
My supervisor.
Oh, the supervisor. My lord, I insist in answers.
My lord,
where the police are, and that's why we are here.
I am not saying the place where they are. Are they doing their normal business? I am not asking for the
do you want to hunt them down?
My lord, I think it's a fair question. He has refused to answer.
Yes.
Were these threats directed at particular individuals or were general in nature? You are not we are saying specifically directed to individuals or were general?
My lord, we shall not relate on coming up, my lord, standing up. These questions are repetitive and they are becoming monotonous.
Okay, let me be directed now.
My lord, if I may be of help.
Witnesses who are not at all threatened.
You can drive your point better without raising your voice. I beg your pardon.
Do you feel intimidated? Do you feel intimidated?
You cannot intimidate me, but raising your voice is rude and uncourteous.
Okay, Mr. Tomo Hendos. With the utmost courtesy. Are all your witnesses at risk, sir?
I have told, my lord, I have already answered that question. As of the time we filed this application,
I'm talking as of now.
I can't tell if the four are also at risk. As of now. You know, circumstances change.
Now, my lord, I would like now to be specific and I ask you to directly answer my questions. From the disclosures, you've disclosed Andrew Wilson, A.K. Orlando, to us. His statement is here. Is he at risk? You've disclosed him as your principal witness. Is he at risk?
And I have told you now I can't tell.
You have the names. I am not here to report the evidence of those witnesses exposed to you.
And my lord,
but for why are you pushing court? Proceed with your cross-examination. But don't reveal these witnesses here until they come to testify.
My lord, I'm making reference to paragraph 7 of his affidavit in Joinda. He is saying all the witnesses were threatened.
What I'm saying, we first give the name of witnesses and if they come to court to testify. Now, are you trying to say here we are here for the protection in respect of 4? 6. The protection in respect of 6. Now, why should we disclose even the 4 they disclosed to you? They disclosed these witnesses. So leave their name here.
My lord, the question is how to understand.
That's okay.
These all the witnesses at risk because he's saying
that question is okay, but give the names. He asked questions, but give the names. Like, are they all?
we have another mechanism where the witness testifies from within court, but in some sort of a constructed, I've forgotten the name, some sort of a kiosk where they testify from.
Which one is that?
Like, there's always something, a small kiosk-like structure that is placed in court with a mirror. The witness testifies from that kiosk. We also have voice distortion. Yes. Paragraph 5.
The affidavit in Joinda the first March.
Is it the one that in referring that paragraphs 5, 6, and 3 of the respondent's affidavit?
5. What does the administration of history?
Maybe my senior can confirm whether I'm reading from the right document.
Which one? Which one are you reading? I've not seen what you are reading.
That in rejoinder to paragraphs 5 and 6, my Lord, I'm praying protection against Mr. Khan. He's interfering. In rejoinder to paragraphs 5 and 6 of the third respondent's affidavit in reply, witness protection is a universal principle in criminal justice for both the prosecution and defense.
Again, let me start with your titles. Is it a principle with the LE or with the AL?
My Lord, it is supposed to be principle with the PE. Principle with PLE.
Would you wish to amend your affidavit again?
Mr. Lukwago, it is.
Answer.
Let's proceed with the way it is.
Would you wish to amend it again?
Let's proceed with the way it is.
I am helping you to correct
I don't want you
mistakes
to
you
help
made.
me.
So it is a principle with the AL?
It doesn't matter. Yes, it is.
Oh, okay. So, this it is with the AL. So, you are saying indeed it's a principle, I mean it's the principal law in the criminal justice system that there must be witness protection.
For deserving cases like this one.
Yes?
For deserving cases like this one. And we say that witness protection is a universally accepted and practiced principle in criminal, at least in criminal law and procedure. And it is available for both the defense and prosecution.
And you say you, that same paragraph, in paragraph 2, in paragraph 2 of the same affidavit.
Mr. Jomo, we'll get to 10. We're still at 8.
No, I'm telling you.
Mr. Jomo, let's read it. Read it out loud.
Yes.
Read it out.
Investigation revealed that Frank Shehere is an accomplice to the respondent threatened to harm one of the witnesses in this matter.
What is the instance of security threat
Harm.
in paragraph 8?
Harm.
Of what the nature of that harm is in paragraph 8?
My Lord, it is just harm.
Is it specified in paragraph 8?
I don't know what detail that you want. According to me, this is sufficient.
So is there a detail or not?
Yes, there is. The word
According to paragraph 8, to all the 6 witnesses.
yes.
So again, in paragraph 8, show me where you make reference to the 6 witnesses.
That is canvassed in the affidavit.
So you confirm in paragraph 8 you make reference to one witness.
Yes.
Maybe a few more things. In your evidence, you don't show how the threats were made. You mentioned nothing about how they were made.
I mentioned how, yes, I mentioned how they were made. I mentioned that they were made.
No, do you please listen to the question? I have read that you have said they were made. That's
Yes, yes.
I am asking you that you have not stated
No,
how they were made.
no. I put it.
Yes or no?
No,
The answer is no.
no. That right.
No, the answer is no. We have left the threats. I'm now talking about loved ones.
My Lord, in paragraph 10,
Mr. Jomre,
in paragraph 10, I mentioned intimidation to the loved one.
when you finish, you can go back further. Because we are still at paragraph.
My Lord, in paragraph 10, I mentioned interference, intimidation, and harm to others.
Let me know when you are done.
What?
Back.
towards the witnesses and their loved ones. Continue.
So can you confirm that there are no instances of threats to loved ones mentioned in your evidence?
In paragraph, harm.
The nature, number one?
Harm.
To the loved ones, specifically the loved ones. Nature of harm, number one?
It is harm.
The nature of harm is the harm.
It is harm. I can't classify it.
That the threats to loved ones is harm. That is good enough.
In paragraph 10, yes. Yes.
We use threaten.
Yes, I can just say Mr. Caliban and threaten.
So no, hang on. Let's start. We have a instance of what can amount to instance, which are spoken can be used to threaten. Words which are written can be used to threaten. The threaten. How was the threaten communicated?
My Lord, I said it was true.
Okay. What does, now you as a lawyer, what does inherent mean?
God given.
God given. All right. So they are ill both. Are they ill both?
I told you they are God given.
And these same rights are in you, in me, in the accused.
Correct.
Including the court.
Correct.
To respect them, to uphold them, and to promote them. Correct?
Correct.
Now, among the rights that are pertinent to this particular matter is where we have gone before fair hearing. It's one of those that is inherent.
Yes.
Correct?
Yes.
It is to be respected,
Yes.
upheld,
Yes.
promoted.
Yes.
Now, I will refer to these ones in 28 as fair trial rights, just for us. Now, these fair trial rights, Mr. Muhendo, we agree are not granted by the state.
No.
We are just continuing from your earlier assertion just now. So if those rights are withheld, there will be no injustice.
If the rights are withheld,
there will be an injustice. Is the fair trial rights that article? Is it one which is among the four from which there cannot be any derogation?
yes.
The derogation is what we talked about earlier, Article 44. Can you just read the beginning words of Article 44 so that we have the two conflicts? Prohibition, first of all, correct? Now read the beginning words, notwithstanding.
Notwithstanding anything in this Constitution, there shall be no derogation from the enjoyment of the following rights and privileges. Freedom from social act, cruel, inhuman, and disgracing treatment or punishment.
Yes, so you can leave the detail, that I think the detail we know. But let's just confirm under Article 40. And the only place it makes reference in emphasizing that prohibition is any other part of the Constitution. Correct? Notwithstanding any other part of the Constitution.
My Lord, I'm not so sure because
It's there. No, what I've been